Imagine waking up one morning, checking your phone, and seeing a notification that says your country has been added to a deportation watch list by the United States government. You didn't do anything wrong. You have a valid visa. You've been living, working, maybe even raising a family here in the United States. And now, out of nowhere, everything feels uncertain. That feeling, that fear, is exactly what millions of people are experiencing right now in 2026. And if you are one of them, or if you know someone who is, you need to watch this video all the way to the end. Because what I'm about to share with you is not just news, it is the truth behind the numbers, the law, and what it all actually means for you. Welcome back to US Visa Explained. I'm so glad you are here. If this is your first time on this channel, we talk about everything related to US immigration: visas, green cards, deportation policies, travel bans, and the legal tools that the government uses to make decisions that change people's lives. Hit that subscribe button right now because every single week we break down complex immigration topics in simple, clear language that you can actually understand and use. Today, we are diving deep into one of the most talked about and most misunderstood immigration developments of 2026, the ICE Deportation Wave, the so-called list of 39 countries, and the legal weapon behind it all, INA Section 217. Let's get into it. First, let me give you the big picture of what is happening. In 2026, the United States Immigration and Customs Enforcement, known as ICE, has dramatically ramped up its deportation operations. We are talking about a level of enforcement activity that immigration lawyers, advocacy groups, and even some government officials are calling unprecedented. Raids in major cities, arrests at courthouses, detentions at workplaces, and deportation flights happening week after week. This is not just political noise. This is real, and the numbers back it up. According to reporting from multiple credible sources, ICE has been operating under a significantly expanded mandate. The enforcement priorities have shifted. In previous years, ICE generally focused on people with serious criminal records, recent border crossers, or people who had recently received final orders of removal. But in 2026, the scope has widened considerably. People who have been in the United States for years, even decades, with no criminal history, are finding themselves caught in this enforcement net. And that has sent shockwaves through immigrant communities across the country. Now, here is where the story gets really specific and really important. There are reports circulating, and you have probably seen the headlines, about a list of 39 countries. What is this list? Where did it come from? And what does it actually mean? Let me explain this clearly because there is a lot of confusion out there. The list of countries being discussed in this context is connected to a long-standing but now aggressively enforced legal mechanism under the Immigration and Nationality Act. Specifically, the mechanism that has been getting attention is related to what happens when a country refuses to accept the return of its own nationals who are being deported from the United States. This is a real and serious problem in the world of immigration enforcement. ICE issues a removal order. It books a deportation flight, and then the receiving country says, "No, we are not accepting this person," or they simply don't respond, or they delay and delay until the deportation becomes practically impossible. When that happens, what does the United States do? For years, the answer was, not much. The deported person would often be released from detention because the law limits how long someone can be held if there is no realistic prospect of removal. But in 2026, the approach has changed. The government is now using a provision of the law to put real pressure on these countries. And that provision is INA Section 217, although I want to be precise here because Section 217 is specifically about the visa waiver program, and the way it connects to this enforcement wave is something we need to unpack carefully. Let me take a step back and explain what INA Section 217 actually is, because this is where a lot of the confusion comes from. The Immigration and Nationality Act is the foundational law that governs immigration in the United States. It covers everything from how you get a visa to how you become a citizen to how you get deported. It is a long and complex law with hundreds of sections. Section 217 specifically deals with the Visa Waiver Program, commonly known as ESTA. The Visa Waiver Program allows citizens of certain designated countries to travel to the United States for up to 90 days without needing to obtain a tourist or business visa in advance. Right now, there are around 42 countries in the Visa Waiver Program, countries like the United Kingdom, France, Germany, Japan, Australia, and others. If you are a citizen of one of these countries, you can apply for an ESTA online, and if approved, you can board a plane to the United States without going through the traditional visa process. Now, Section 217 contains specific requirements that countries must meet in order to remain in the Visa Waiver Program. These requirements include things like sharing security information, using electronic passports, maintaining a low visa refusal rate, and, here is the key part, cooperating with the repatriation of their nationals who are being deported from the United States. That last requirement is the one that is driving the current conversation. The United States government has made it very clear that if a country does not cooperate with deportations, if they refuse to accept their own citizens being sent back, then that country risks consequences under the Visa Waiver Program framework, and those consequences could include suspension or termination from the program entirely. So when people talk about a list of 39 countries in the context of Section 217 and ICE deportations, what they are really referring to is a list of countries that the State Department and the Department of Homeland Security have flagged as non-cooperative or partially cooperative when it comes to accepting deportees. Some of these countries are Visa Waiver Program countries, others are not. But all of them are facing diplomatic pressure from the United States to change their behavior. And for some of them, the pressure has moved beyond diplomacy into actual policy consequences, including potential visa restrictions for their citizens traveling to the United States. Now, I want to be very honest with you here. The specific number 39, where does it come from? The truth is that different reports have cited different numbers. Some say 39 countries, some say closer to 20, some say the number fluctuates depending on how cooperation is measured and which agency is doing the measuring. What is clear is that the list is real, that it includes countries from every region of the world, and that it is being used as a tool to force compliance. We are talking about countries in Africa, Latin America, the Caribbean, the Middle East, South Asia, and Southeast Asia. Some of the countries that have historically been mentioned in reports about non-cooperation include Eritrea, Cuba, China, India in certain contexts, Vietnam, Cambodia, and others. But again, the specific composition of the list at any given moment is something that changes based on diplomatic negotiations and bilateral agreements. Here is something else you need to understand. This is not a new legal concept. The authority to use visa sanctions against countries that refuse to accept deportees has existed in U.S. law for a long time. Specifically, there is a provision in the Immigration and Nationality Act that allows the Secretary of State to order the suspension of visas for nationals of a country that the Secretary of Homeland Security certifies is not accepting the prompt return of nationals. This authority has been used before. It was used against Guinea, Sierra Leone, and Eritrea in previous administrations. But what is different in 2026 is the scale, the speed, and the political will behind these enforcement actions. The current administration has made immigration enforcement a central policy priority, and it has shown a willingness to use every available legal tool aggressively. That means ICE is conducting more raids, processing more deportation orders, and following through on removal more consistently than in recent years. It also means the State Department is pushing harder on foreign governments to accept deportees. And for countries that resist, the consequences are becoming more concrete and more immediate. So, what does all of this mean for actual people? For immigrants living in the United States right now? Let me break this down into several groups because the answer is different depending on your situation. If you are an undocumented immigrant, or someone who has overstayed a visa, or someone with a final order of removal, the current environment is genuinely dangerous. ICE is operating with broader enforcement priorities than it has in recent years. Being in the interior of the country does not protect you the way it might have a few years ago. This does not mean you should panic, but it does mean you need to know your rights and you need to have a plan. If you have not already spoken with an immigration attorney, now is the time. There are organizations that provide free or low-cost legal help, and knowing your rights before an encounter with ICE can make a significant difference in what happens next. If you are a citizen of a country that is on one of these non-cooperation lists and you are living in the United States legally, on a visa perhaps, or waiting for a green card, you may be wondering how this affects you. The honest answer is that if you are maintaining your legal status, you are not a primary target of current ICE enforcement. But you should be paying attention to any changes in visa policy that might affect your ability to renew, extend, or change your status. If your country faces visa sanctions, that could create complications even for people who are trying to follow the rules. If you are a citizen of a visa waiver program country and your country is under scrutiny for not cooperating with deportations, you should be monitoring the situation closely. A suspension from the visa waiver program would not happen overnight. There would typically be warnings, diplomatic negotiations, and a process before any formal action. But the possibility is real, and if your country loses visa waiver access, you would need to start applying for a traditional visa before traveling to the United States. That is a significant change in terms of time, cost, and uncertainty. Now, let me talk about something that I think is really important, and that does not get enough attention in the mainstream coverage of this topic. When we talk about deportation waves and enforcement crackdowns, it is easy to focus only on the legal and procedural aspects. But behind every case number and every removal order, there is a human being. There are families being separated. There are children who are U.S. citizens watching their parents be taken away. There are people who have built entire lives in this country, who have businesses, who have homes, who have deep roots in their communities, facing the prospect of being sent to countries they may barely remember, or in some cases, countries they have never lived in as adults. I say this not to take a political position, but because understanding the human cost of these policies is essential to understanding why they matter and why so many people are paying such close attention to developments like the 39-country list and the use of Section 217. Immigration policy is not abstract. It affects real people in profound ways, and anyone watching this channel deserves to have that truth acknowledged along with the legal and procedural facts. Let me now go a little deeper on the legal side of things, because I know many of you watching this are students of immigration law, or you are going through your own cases and you want to understand the machinery of what is happening. Let me walk you through how a deportation case actually works, what the role of ICE is, what the courts do, and where the international dimension comes in. When someone is placed in removal proceedings, they receive a notice to appear before an immigration court. This is a document that tells them the government's charges against them, typically that they are present in the United States without authorization, or that they have violated the terms of their visa, or that they have a criminal conviction that makes them removable. The person then has the opportunity to appear before an immigration judge, present their case, and potentially apply for relief. Things like asylum, cancellation of removal, adjustment of status, or other forms of protection. If the judge orders removal and the person does not appeal, or if they do appeal and lose, they receive a final order of removal. At that point, ICE has the authority and the obligation to carry out that order. But here is where the international dimension comes in. Once ICE has a final order of removal, it needs to actually remove the person. That means booking a flight, coordinating with the receiving country to accept the person, and physically transporting them. And this is where countries on these non-cooperation lists cause problems for the system. When a country refuses to issue a travel document for its returning national or refuses to accept the deportation flight, ICE is stuck. It cannot just drop someone off at the border of a country that won't accept them. International law and practical logistics both require the cooperation of the receiving country. That is the leverage point. That is why the United States government uses visa sanctions and other diplomatic tools against non-cooperating countries. By threatening to restrict or eliminate visas for citizens of those countries, the U.S. government creates economic and political pressure on foreign governments to change their posture. For countries where a significant number of citizens travel to, study in, or work in the United States, that is real leverage. For countries that have fewer ties to the United States, the leverage is weaker, which is why some countries remain on these lists for extended periods. There is also something called the Zadvidas Doctrine, which comes from a 2001 Supreme Court case, Zadvidas versus Davis, that you should know about if you are following this issue. The Supreme Court held in that case that the government cannot detain someone indefinitely simply because no country will accept them. After a certain period, roughly 6 months, ICE must release someone from detention if there is no significant likelihood that removal will be carried out in the reasonably foreseeable future. This is an important protection that still exists in the law, but the current administration has been testing the edges of this doctrine, arguing in some cases that even if removal has been difficult, it is still foreseeable, and therefore extended detention is justified. Courts are actively litigating these arguments right now. Another layer of this story involves third country removals. This is something that has generated enormous controversy and legal challenges in 2026. The current administration has been attempting, in some cases, to remove people not just to their country of nationality, but to third countries, countries they have no connection to, when their home country will not accept them. Legal challenges to this practice have been filed in multiple federal courts, and the outcomes of those cases will have significant implications for how far the government can push these enforcement mechanisms. I also want to address the asylum dimension of this because it matters enormously. If someone has a pending asylum case, if they have a credible fear of persecution in their home country, they have legal protections that should prevent their removal while that case is pending. The problem is that the current enforcement environment has created situations where people are being detained and in some cases removed before their asylum cases are fully resolved. Immigration advocates and legal organizations are sounding alarms about due process violations, and federal courts have been issuing emergency stays in some cases to pause removals while legal challenges are heard. This is an area where the law is genuinely in flux, and staying informed is critical. Let me now address something that comes up a lot in the comment sections and in conversations within immigrant communities: the question of whether there is anything you can do if you or someone you know is in this situation. Yes, there are things you can do. Let me go through them. First, know your rights. If ICE comes to your door, you have the right not to open the door unless they have a judicial warrant. Not just an administrative warrant signed by an ICE officer, but a warrant signed by a judge. You have the right to remain silent. You have the right to speak to an attorney. These rights exist regardless of your immigration status. Knowing them in advance and having a plan, including a list of phone numbers for immigration lawyers or legal aid organizations, can make a real difference. Second, document everything. If you have any kind of legal status, keep your documents organized and accessible. This includes your visa, your passport, any notices you have received from USIS or immigration court, receipts for applications you have filed, and any evidence of your ties to the United States. If you are ever detained, having this documentation available quickly can help your attorney argue for your release. Third, find qualified legal help. Not everyone who calls themselves an immigration consultant or a notario is qualified to help you. In fact, many people have made their situations worse by paying unlicensed individuals who gave them bad advice or filed fraudulent applications on their behalf. Look for a licensed attorney, someone who is a member of the state bar and who has specific experience in immigration law. Organizations like the American Immigration Lawyers Association have directories you can use to find qualified help. Fourth, understand the difference between types of relief. Deportation is not always the end of the road. Depending on your specific situation, you might be eligible for things like voluntary departure, which gives you time to leave on your own terms and may preserve some future immigration options. You might be eligible for a stay of removal while you pursue an appeal or a motion to reopen your case. You might have a U.S. citizen or lawful permanent resident family member who could petition for you. Every case is different, and only a qualified attorney who knows your specific facts can tell you what options are available. Fifth, stay informed. The law and enforcement policies are changing rapidly right now. What was true 6 months ago may not be true today. Following credible sources of information, including channels like this one, reputable immigration law blogs, and nonprofit immigration organizations, is important. Be careful about misinformation on social media, where false or misleading claims about immigration policy spread very quickly. Now let me zoom out a little and put this in context of the bigger picture of where U.S. immigration policy is heading in 2026. The current enforcement wave is part of a broader policy agenda that combines increased interior enforcement, expanded use of expedited removal procedures, reduced access to asylum, increased use of detention, and diplomatic pressure on foreign governments through tools like visa sanctions. Taken together, these elements represent a comprehensive strategy to reduce unauthorized immigration through deterrence and enforcement rather than through pathways and regularization. Whether you agree or disagree with this approach as a matter of policy, understanding it clearly is essential if you are navigating the immigration system or trying to help someone who is. The system is not operating the way it was 3 or 4 years ago. The assumptions that guided decisions about whether to pursue a case, whether to stay in the country while waiting for an outcome, or whether to come forward and regularize a status, those assumptions need to be updated based on the current reality. I also want to say something about the international dimension of this story that goes beyond the deportation question. The use of visa sanctions as a diplomatic tool, cutting off or threatening to cut off visa access for citizens of countries that don't cooperate with us removal operations, has implications that extend far beyond immigration enforcement. It affects trade relationships, educational exchanges, tourism, and the broader diplomatic relationships between the United States and dozens of countries around the world. Some countries that are on these non-cooperation lists are also important partners for the United States in other areas: economic partnerships, security cooperation, counterterrorism efforts. The use of visa sanctions as leverage in deportation negotiations means the United States is choosing, in some cases, to prioritize immigration enforcement even when it creates friction in those broader relationships. That is a significant foreign policy choice, and its long-term consequences are still unfolding. There are also questions being raised within the immigration advocacy community about whether some of the countries on these lists face genuine practical obstacles to accepting deportees. Issues with documentation, identity verification, or the administrative capacity to process returns at the volume the United States is seeking. The binary of cooperating versus non-cooperating can obscure these complexities. And when real people are at the center of these bureaucratic and diplomatic failures, the human cost is real, regardless of where the technical fault lies. Before I wrap up, I want to make sure we revisit the core question that many of you probably came to this video to get answered. Is the list of 39 countries real? And if your home country is on it, What does that mean for you? The answer is the concept is real. The list as a specific fixed number is more fluid and uncertain than the headlines suggest, and what it means for you depends heavily on your individual circumstances. If you are a citizen of a country that has been identified as non-cooperative and you are living in the United States without authorization or with a final order of removal, your risk is heightened in the current enforcement environment. If you are living here legally and maintaining your status, your most immediate concern is monitoring for any visa policy changes that might affect your renewals or your travel. If you are a citizen of a visa waiver program country whose country is being scrutinized, you should watch for any official announcements about changes to that program. And regardless of which of these categories you fall into, the most important thing you can do is stay informed, know your rights, and have access to qualified legal help. Immigration law is complicated under the best of circumstances. In an enforcement environment like 2026, having good information and good counsel is not a luxury, it is a necessity. I know this was a lot of information, and I know that for many of you watching, this is not just an academic topic. This is your life, your family, your future. I want you to know that this channel is here to give you real information, not sensationalism, not panic, not vague reassurances, but clear, honest explanations of what the law says and what is actually happening. That is what US Visa Explained is about, and that is what we are committed to doing for you. If this video helped you understand something that was confusing before, please give it a thumbs up. It genuinely helps more people find this content when they need it. Share it with someone in your community who needs to hear this. Drop a comment below and let me know what questions you still have or what topics you want me to cover next. Your comments shape what this channel covers, and I read every single one of them. And if you are not subscribed yet, please do that right now. Hit the bell icon so you get notified every time we post a new video. We cover visa updates, policy changes, green card processes, naturalization, and everything in between. This is a community built on information, and we are stronger when more people have access to the truth. Thank you for watching us, A Visa Explained. Stay informed, stay prepared, and I will see you in the next video.